Sensei, and we are teaching commercial transactions, sale of goods, and this is our 7th module. Wonderful. We've come a bit. Congratulate yourself. You've been consistent with it, you've been staying with us. Pretty sure you've learned a lot by now. Thanks for sticking with us. We've come quite far. Okay, today's module is going to be on the transfer of property on unascertained goods. In the last module, we treated transfer of property specific goods. This module, we're going to treat transfer of property for unascertained goods. So please get your Sale of Goods Act and just try to follow us. We're going to have a wonderful time together. It's going to be wonderful. Yes. Section 16 of the Sale of Goods Act states that no property is transferred until the goods are ascertained. We mentioned that in the last module that no property is transferred until the goods are ascertained. Meaning that when we are dealing with unascertained goods, those goods have to be ascertained first before there can be any transfer of property. That's the position under the Sale of Goods Act of 1893. And you will know why I'm saying this, why I specifically said that at the end of the session. Now, once they become ascertained, section 17 applies to those goods as it does just to any other specific goods, in that property is transferred when the parties intend for it to. Once the goods become ascertained, then section 17 applies that in the same way it does to other specific goods, that property is transferred when the parties intend it to. If, however, the parties fail to make their intentions clear, then recourse will have to be made to section 18, rule 5. Section 18, rule 5. Please take note. Despite the fact that these unascertained goods have become ascertained, and despite the fact that section 17 applies normally as it would to specific goods, that yes, the intention of the parties is what determines when property will pass, it is best not to make the mistake of thinking that yes, you have to apply the rules of section 18 from rule 1 to 4. No, those do not apply to unascertained goods. We are going straight to rule 5 when we are dealing with unascertained goods. So rule 5 sub 1 states that where there is a contract for the sale of unascertained or future goods by description, and goods of that description in a deliverable state are appropriated to the contract, either by the seller with the assent of the buyer or by the buyer with the assent of the seller, the property in the goods then passes to the buyer. It sounds like a mouthful, I know, but we'll break it down bit by bit. Say where there's a contract for the sale of unascertained or future goods. We're dealing with unascertained goods, goods that you've not seen yet, goods that you're buying based on the description. And say that when goods of that description in a deliverable state, we've already defined what the deliverable state is in our last module, is where goods are in such a condition that the buyer will have no other choice but to accept them under the contract. So when they are appropriated to the contract, either by the seller with the assent of the buyer. Now, what is appropriation? Appropriation is similar to ascertainment, but it goes deeper. Appropriation is when it has been made clear that the goods are specifically for that particular contract and for that contract alone. Therefore, they are for that particular contract and for that contract alone, meaning that those goods cannot be given to someone else. If that is done, it is a breach of that sale of goods contract. Yeah. So, where they are appropriated to the contract, either by the seller with the assent of the buyer or by the buyer with the assent of the seller, there has to be assent when there's appropriation. Then that's when the property passes to the buyer. And this assent might be expressed or it might be implied. It can be implied from their conduct that yes, the seller might have told the buyer, yes, these are your goods and these goods are for you and you alone. They will not be sold to anyone else. They've been brought out from the bulk and everything. They've been labeled as yours. The seller has made it abundantly clear, and the buyer, even though he does not expressly say it, by his conduct, he has accepted. The assent may be given either before or after the appropriation is made. And if the assent is given after the appropriation is made, then property passes not at the time of the appropriation, but at the time when the assent was given. So, Rule 5 sub 2 states that where the seller delivers the goods to the buyer or carrier or bailee or custodian named by the buyer, whether the custodian is named by the buyer or not, whether the carrier is named by the buyer or not, for the purpose of transmission to the buyer, where the seller delivers the goods to like a go-between to deliver it to the buyer, and it doesn't reserve the right of disposal, it is deemed to have unconditionally appropriated the goods to the contract. In this kind of situation, it is deemed to have unconditionally appropriated the goods to the contract. And there are two requirements to bring this to be. One, there must be an unconditional appropriation. There must be an unconditional appropriation. Remember, when we were explaining Rule 5, Sub 1, we mentioned appropriation. The appropriation must be unconditional, not just separating to use for a particular contract. It is required that there be further action by the seller to show that the goods are irreversibly attached to that particular contract, in such a way that, yes, there is no doubt in anybody's mind that these goods are for you. They've been labeled for you, and they will be for you, and therefore they are for you. And if anything happens and he sells the goods off to someone else, there's a breach. So, and the case that emphasizes this is Carlos Federspiel and Co. versus Charles Twig and Co. Carlos Federspiel and Co. versus Charles Twig and Co. Like I always say, it is always important to consult materials on these things. It is very easy, and it's very easy to watch a video of 15 minutes or so, and I know that our sensei videos are very, very well packed, but it's also important to consult notes to get a deeper understanding of the foundation and explanations we're giving here. Okay, so goes on to say that this unconditional appropriation is still subject to some rules, but I'm getting there. Our situation in Rule 5 Sub 2, it gives a premium example of unconditional appropriation, in the sense that, look at it, when we're giving the provision of Rule 5 Sub 2, we said that the seller delivers the goods to a carrier without retaining the right of disposal. The right of disposal is a kind of situation maybe that the seller reserves ownership of the property until certain conditions are fulfilled, and most of the time that condition is like the payment of price. So, but Rule 5 Sub 2 gives a premium example of what unconditional appropriation is. That the seller delivers the goods to the carrier without reserving the right of disposal. That means in that type of situation, the goods have been unconditionally appropriated to that contract, thereby fulfilling the condition for Rule 5. Same. But note, this is still subject to the condition that the goods must be clearly identified. It is still subject to the condition that the goods must be clearly identified. In Healy versus Howlett and Sons, so he was delivering his goods by rail. They were just marked, they were in boxes. They were not marked according to the owners of the boxes. There was an arrangement he had with the railway company that when you get to the appropriate stops, just give them according to the numbers. So they were not marked. And the court held that putting it on a railway was not an unconditional appropriation, as it was impossible to determine which boxes were appropriated to any given buyer. Meaning that the railway company could decide to, give these 2 random boxes to this person, give the other 2 random boxes to another person entirely. Even though those goods were all the same, there was no unconditional appropriation, in the sense that they were not labeled or anything according to the specific buyers. Yes. Okay. And unconditional appropriation won't pass property unless the other party assents. That was one of the major things we mentioned before, that there must be assent. And like we said before, sometimes it might be difficult to show, but it can be implied from conduct. And it can be given after the unconditional appropriation is made. And when it can be given after the unconditional appropriation is made, or it can be given before. If it is given after, property will pass not when the appropriation was made, but at the time when the party's assent was subsequently given. And this can be seen in the case of Pignataro versus Gilroy. It seems like a lot of information to take in, but if you go up by it step by step, it is easy to understand. And now we come to the right of disposal. I mentioned it earlier in Rule 5 Sub 2. The right of disposal. Usually nowadays when we do business, because of the risks that come with it, sellers, they do business on credit. And it will be dangerous if you sell something to someone and maybe the buyer is unable to pay later on, or the buyer goes bankrupt, and that means that your thing that you have sold to the person has now entered the wind, has entered voicemail, while has become like bicycle, and you don't know what to do. So that's where this right of disposal, reserving the right of disposal comes in. It serves as a protection for sellers. That means that property in goods wouldn't pass to the buyer until some condition is done, like I said before. And usually the condition that the sellers attach to this reservation of the right of disposal is the payment of price. Now, Section 19, Sub 1 of the Sale of Goods Act of 1893 deals with this. It states that property in goods, either specific or unascertained, doesn't pass if the seller reserved a right of disposal of the goods. Straightforward and simple. Apart from this express reservation, that the seller has expressly reserved the right of disposal, it is also implied in two instances that the seller has reserved the right of disposal. And this deal mostly with when goods are being shipped. In sub 2 of that same section 19, it says that where goods are shipped and by the bill of lading, they are deliverable to the order of the seller or his agent, the seller is prima facie deemed to reserve the right of disposal in that kind of situation. In sub 3, it goes on to say that where the seller sends a bill of exchange with a bill of lading, property does not pass to the buyer unless he accepts the bill of exchange. He can't just take the bill of lading and say he doesn't want the bill of exchange because the seller is trying to protect his own investment. In such a scenario, it is implied that there is a right of disposal reserved, and that same thing we said to in sub 2. Now we move on to Romalpa clauses. Romalpa clauses is a lot of information in, but by God's grace we'll be fine. Romalpa clauses. This came about as a result of the question, what now happens where even though you've sold the goods to someone else, yes, and that person resells your goods or uses the thing you've sold to them to create something else, and yet they've not paid you fully. So what becomes your own stake in the entire matter if you are not paid? So sellers have been able to protect themselves in situations where the goods have been resold or transformed through a manufacturing process through the use of Romalpa clauses. And this started from the locus classicus case of Aluminium Industry Vasen BV versus Romalpa Aluminium Limited. I'll say that again. Aluminium Industry Vasen BV versus Romalpa Aluminium Limited. In that case, sellers sold aluminium foil to the buyers. So the buyers they manufacture aluminium-based products, and so the sellers, they had a clause in their contract that stated that ownership wouldn't pass to the buyer until the foil was paid for. And if the foil was used to manufacture other things, because they were aware that most of their buyers would use such aluminium foils to create other aluminium products, they said that if the foil was used to manufacture other things, the seller would become the owner of the finished product and property wouldn't pass until the buyer paid for the foil, so as to protect themselves from being left hanging in the wind in case something happens and maybe the buyers go bankrupt or whatever, so that they won't become unsecured creditors. So in that case, the buyers became insolvent, went bankrupt, and then the sellers instituted this action to get back their property, the remaining property, and to get back the price for the ones that were already used. And then the Court of Appeal held that the seller was entitled to recover both the unsold mixed foil and the proceeds of the subsale of the foil. That's how Romalpa clauses came to be. It's basically sellers trying to protect themselves and trying to ensure that they get the value of their goods, even though those goods may have been resold to someone else, or those goods have been used to manufacture something else. Is to ensure that yes, property still remains, ownership still remains in them. Therefore, if something happens to the buyer becomes insolvent, they won't just be unsecured creditors, they'll be secured creditors in the sense that the property has not yet passed to the buyer. Now, I mentioned something that towards the end, you understand why I said that Section 16 of the Sale of Goods Act of 1893 says that no property is transferred until the goods are ascertained. But the position is slightly different under the Sale of Goods Law of Lagos State. Sale of Goods Law of Lagos State. Section 20 of the Sale of Goods Law of Lagos State deals with undivided shares in goods forming part of a bulk. In that scenario, they realized that yes, it is better to modernize it a bit and that therefore property can pass in unascertain goods. That's under the sale of goods law of Lagos State. The property can pass in unascertain goods in some instances. And then there was a case that buttressed this a lot, and that was Afrotech Technical Services Limited and MIA and Sons Limited. It's a very wonderful case. You should actually check it out to make you understand the whole issue of transfer of property much, much better. Thank you for sticking with us. This has been Learning with Sensei, and I'm actually quite glad that I've been your sensei so far. This still remains Enoch. Please like, share, comment, and subscribe. Help us. As we are helping you to help us, please, thank you. Because we create good content and we believe that people should get to see it. Help others. Thanks.